East Hampton Village, ZBA, you are live.
Good morning and welcome to the Zoning Board of Appeals meeting for Friday, January 9th. Tim, are you going to do the roll call?
Yes.
Thank you.
Mr. McGurk?
Here?
Mr. McMullen?
Here.
Mr. Rose?
Here.
Mr. Barris?
Here.
Ms. Fitzsimons?
Here.
Mr. Carmody has an excused absence. Mr. Darko?
Here.
And I am present, Tim Hill.
Thank you, Tim. We have three determinations today. And we're going to do the first two, and the files are available at Village Hall if you'd like to review them.
Chairman, did we want to approve the minutes?
Oh, forgot about that. Thank you. We have the minutes for December 12th, 2025. Can I have a motion, please? Second?
Second.
All in favor?
Aye.
Thank you. Thank you, Tim. Again, we have three determinations today. We're going to read the two right now, and then we'll read the third determination when the file is complete. And the files are available at Village Hall. The application of 7 Chauncey LLC, 7 Chauncey Close, Suffolk County Tax Map Number 301-15-6-2 for area variance and wetlands permit is granted. May I have a motion? Second, please.
Second.
Tim, would you please poll the board?
Mr. McGurk?
Yes.
Mr. McMullen?
Yes.
Mr. Rose?
Yes.
Mr. Barris?
Yes.
Ms. Fitzsimons?
Yes.
Okay, next on the agenda is the application for Renero and Lisa Diaversa, 6 Georgia Could Close Road, Suffolk County Tax Map Number 301-7-4-17 for area variances and a wetlands permit to construct additions to an existing residence walkway, outdoor shower, drainage, and reconstruct and expand a driveway is granted. May I have a motion?
So moved.
Second?
Second.
All in favor?
Aye.
Mr. McMullen?
Yes.
Mr. Rose?
Yes.
Ms. Fitzsimons?
Yes.
Mr. Darko?
Yes.
Okay.
Thank you, Mr. Rose.
Taking up for the third application is of Bowen Builders LLC, 63 Meadow Way, SCTM number 301-8-4-10.2 for an area variance to construct an addition to an existing residence is granted. Motion?
Motion.
Second?
Second.
Okay. Tim, will you poll the board?
Mr. Rose?
Yes.
Mr. Barris?
Yes.
Mr. Darko?
Yes.
Okay, thank you. Moving on, so we have one adjournment today. I think we're going to hear the 25 Apcog Road. So we have one adjournment, 19 Hook Pond Lane, 19 Hook Pond Lane. And we'll move into the continued hearings, 32 Ocean Avenue LLC, 32 Ocean Avenue. Morning.
Good morning, board members. Karen Hoag from Timmy Latham. At the December meeting, the board had asked for a written confirmation from the neighbor at 28 Ocean that they had no objection to the construction of the garage. On December 16th, we provided written confirmation from Pam Blackman, owner of 28 Ocean, saying that she had no objection to the detached garage.
Thank
So
you.
we'd like to request that the public hearing be closed and that the board render a decision.
Thank you. Thank you. Anybody have any comments?
No. I make a
Anybody?
motion to close.
Okay, anybody in the audience have any comments? Okay. Jimmy's made a motion to close, so I will second it. All in favor? Aye.
Thank you.
And we've had this on the agenda for quite a long time. We're going to do the determination now. The application of 32 Ocean LLC, 32 Ocean Avenue, Suffolk County Tax Map Number 301-8-13-16 for area variance to construct a detached garage is granted. May I have a motion?
So moved.
Second?
Second.
Tim, can you poll the board?
Mr. McGurk?
Yes.
Mr. McMullen?
Yes.
Mr. Rose?
Abstain?
Mr. Barris?
Yes.
Mr. Darko?
Yes.
Okay, thank you.
Thank you.
The next continued hearing is 127 Main Street LLC. 127 Main Street.
Good afternoon, board members. Richard A. Hammer from Beyond and Hammer. I just have two things I want to hand out to you that I thought would be helpful for you guys to have.
Thank you. And just so we're clear, who's sitting on this application, it's myself, Mr. McMullen, Mr. Rose, Mr. Barris, and Mr. Darko.
Good afternoon, Richard A. Hammer. What I handed out to you, one are the color slides. We had those last time, but they were in black and white, so they kind of lost a lot of their appeal. I have the same slides here as well if you want me to refer to any of them, but I think they're very illustrative. I'm here representing 127 Main. I have Tara Burke from Lighthouse Land Planning, and Roy Deline is here. Mr. Carmelli is unfortunately under the weather today. The continued hearing, at the close of the hearing, it was requested we research whether this board has ever granted a variance for new construction of an interior shower on a pool, sort of a novel question that may be of some value. I did research as best I can using the village website. I was unable to locate a fact pattern that mirrors our current fact pattern. There are certainly quite a few interior showers on pool houses throughout the village. I found records for 118 Lily Pond Lane, 1750 in Lane, 49 East Hall, 33 Windmill, 116 Pandago Lane, and a few others. They're all distinguishable from this application in one way or the other. I'll submit copies of those for your council to look at. A more typical variance application for a pool house in the past were variances to utilize an existing structure that's typically over the gross floor area limitations of the village code by walling off a portion of the interior space to accommodate the pool house. I at least received one of these at 156 Georgica Road. There are quite a few others out there, 96 Egypt Lane, for instance. The code was subsequently changed after that to permit this type of pool house addition, basically. Those approvals typically have conditions requiring that there not be an interior shower, and largely for good reason. One of the chief concerns raised by having interior showers on a pool house is to discourage the conversion of these spaces into cottages, which can be occupied with sleeping accommodations, clearly much more attractive in a larger structure. There are also a number of interior showers in pool houses that were approved by the building inspector, presumably in error. I know two of offhand. I'm sure Mr. Hayjack has others, 49 East Hollow and another one on Pandago Road. They received a building permit for the interior shower and then a CO, and it's noted on the CO as being pre-existing non-conforming to the current Board of Appeals interpretation of the same. It's difficult to understand the reference, but I think the village code did have showers prohibited in pool houses for quite some time, but in any event, some of these were approved and became legal because of this error. In the case of 127 Main, the pool houses could never be a guest house. Our pool houses conform to the square foot limitations of the village code. One building containing a changing room, the other contains an interior shower. There are floor plans in what I handed up. This shower was originally proposed to be exterior, but during the course of construction, it was altered without understanding that this would violate the code. They're unusual buildings if you've looked at them, and it was likely changed for pure aesthetics. They're glass cubes, so I can imagine that the introduction of an outdoor shower attached to one of the glass cubes would violate the symmetry and the whole appearance of these things. The property is large and unique that would qualify for an accessory dwelling unit under our code, could even be subdivided. This was never about having a second dwelling. Clearly, the owner could have this if he legally wanted to. Further mitigating any concern, these structures are essentially see-through glass. Shower provides no privacy at all if you like the interior space. Another unique aspect is the location of the pool house is literally hundreds of feet, and one of those attachments that I sent you actually shows you the depth of the property. It's, I don't know, 700 and some feet from the rear of the tennis court to the main residence. So I'm sure this is probably an interior shower. It makes more sense to have a private shower that far away from your main residence, where it can be clean and winterized and you're used to service the pool and tennis court if you're transitioning from one structure to the other and want to use the pool. I know several of the board members have visited the property. I think that's apparent when you visit it. It doesn't seem to have any potential for adverse impacts, and it would provide enormous benefit to this applicant in compliance with variance standards. We do not have a desire to apply for an accessory dwelling unit, but it would be far preferable to a 250 square foot pool house with an interior shower. Other properties clearly have these without a detriment to the community. It's so unique in this case, I don't think it'll be visible to anyone and no potential detriment. That being said, there is the key issue. This was installed without prior approvals from, and also by a current member of the Zoning Board of Appeals. This construction happened during the storm of COVID. There's lots of uncertainty on the construction means, the approvals, the materials that we had, and that's why there was a long history in terms of changing the design because some of these things were unavailable. It should not have happened, but it did. The cure would be to remove the shower from the structure to comply with the code, but based on the circumstances and merits of this application, we elected to seek a variance and for this to remain for the reasons that I've been parroting to the board. Nevertheless, I would think this would have been a particularly good application before, and it doesn't mean that it's not a good application after the inclusion of the interior shower. This is one scenario where an enclosed shower poses no danger to future violation of the village code at all based on the unique attributes of the property. I would rather approach this board, and I'm sure this owner would as well, asking for permission rather than forgiveness, but I just can't rewrite the history here. I do think balancing all the factors, the property was and is a compelling candidate to allow this variance to be granted to permit the interior shower. The second issue I wanted to briefly address is the garage. I gave you a copy of the ZBA approval from October 25th, 2019 that approved this structure, and it was approved even in the zoning board file as a garage/greenhouse. Basically, everyone understood this was not a typical garage structure. It had morphed several times over in its application history, but it's even in the zoning board decision that it would be used to display and shelter automobile collection and store specimen plantings on the site during off seasons. So there was no subterfuge. Basically, this structure and its use was exactly is consistent with what we were telling the board from 2019 on. I do remember discussing the driveway to the building at the time. There's no real definition of a driveway or improved driveway under the village code. We have a stone wheelbase constructed out of limestone and feldspar that serves this building from where the pavement ends. If you've been to the property, the pavement ends is about 150, 180 feet to the structure. It's a common access feature in Ireland, all over Europe, historical houses, I've since learned. It's also compatible with the structure and its use, and it's located in the very rear yard, I think extending the pavement, that extra distance to create a paved driveway would be more of a scar to a landscape than a beauty mark at the end of the day. It's a feature noticeable that when you walk the property, but it would only make sense if this were used by motor vehicles and motorcycles periodically. So we would submit that this does comply as an improved driveway under the village code, which is an undefined term. We feel it's compliant and consistent with the historical aspects of the home, and in fact, it renders this structure compatible with its surroundings, and it's actually ideal for its intended use. We also demonstrated the existing door width is sufficient to allow a building to be accessible for motor vehicles. In fact, it's the same door opening that exists on the pre-existing manager's cottage garage door. And if you've been to the property, the gate that goes through is actually pretty narrow. I don't know if you ever tried to drive a car through that. And that was a historical attribute of the existing house. Now, I think it's 78-inch wide door, which accommodate any car intended to store in this space. There was an additional variance to permit this structure to have, which is glass, to have 2 additional rooms. There are pictures of the rooms that are in this handout that I handed you that are much more illustrative than what I could speak to. It has a boiler in it. It's used for heating during the winter. It's a source of ignition. It kind of made sense to have that separated from the main space for safety purposes. The second room is a small 54 square foot storage closet. You have a glass building. Basically, it was designed to make it so you could store things without it being unsightly. I did want to point out that this building has been essentially downgraded from what was originally approved. This is single-walled pane glass. It was originally proposed to be a double-walled insulated pane. It was supposed to be heated and cooled to store the automobiles. It now contains only heat without the AC, and the single pane glass would make cooling this building which you would expect if it were occupied, nearly impossible. As Shahab has told me that his record was 120 degrees in the interior of this building in the summer, and it regularly exceeds 100 degrees. Certainly the prohibition on other rooms is related for its potential use as a cottage. Once again, impossible to have a glass cottage, or maybe it isn't, but certainly nothing I've ever encountered. And if the owner wanted to build a house, he could do it as a right. The rooms are safety and a small closet for aesthetics only, no detriment to the general health, welfare, and safety that would outweigh the reasonable benefit this building that was approved. Property is fully constructed after a long period of construction and permitting. The last impediment to closing is to close out the permits, is to obtain the variances and the determination we've requested. I think it's a beautiful project. It's one that the DRB really liked. It's a beautiful addition to the property, and we'd love to close this out after all these delays. But my client did give me a book of all the pictures of the historical, construction that was done to restore this property. It's an interesting thing. I don't think I would submit them to the board, but it shows just how much work was done to maintain and to protect this structure after decades or maybe even longer of disrepair. So they really invested a lot of their personal energy and capital into this property to make it as beautiful as it is today, and I hope the board agrees. Other than that, I'm available to answer any questions you might have.
Board members? So is there a reason why the original submission had a driveway going to the garage, and that they chose just to stop it at the pool house and then continue with?
Well, I think originally that was a surveyor's drawing. It wasn't done from the landscape architect's ideas. It was just drawn on the survey, so it didn't have a cut sheet of exactly what they were proposing to do. I think it was altered during construction because they realized that to extend that pavement an extra 180, 200 feet to the rear of the building was going to be a much more detrimental addition to the property than they had hoped for.
And this driveway that's there now, which are two basically tire
strips, yes.
Will he be willing to take them all the way to the building? Because right now they stop just short.
Certainly. Yeah, I think they were done, basically they wheel things up, and at that point they can transition, but they could make it fully up to the building. I will say I have seen quite a few of these in the village. Back in the day, they used to do them with concrete, and they never set it low enough that it was underneath frost heave. So every one I've seen, they come up and they turn, and but it is a pretty common thing in East Hampton Village, particularly up in the Drew Avenue area. I remember looking at several of these with the old school, concrete strips. It's very common in Europe as well.
Mr. Rose? I just have an observation, which is that there are the particulars of the location and the mechanics of it, and then there are the standards in terms of precedent of what constitutes a driveway, what constitutes a garage building, and what the standards are in terms of what the village applies to those criteria. That it's not just whatever a property owner decides. So whether it's a motorcycle or a mini that could fit in, but not an actual standard size vehicle, I think that's the challenge that we have to weigh and consider in this. So there's a precedential component to this.
Well, there is, but you have to kind of mute it by the fact that this is such a unique property and such a unique structure.
I'm not debating. I'm raising the point that I think there's a balance between the unique conditions of a particular property, and then there's the general standards in terms of, is it a cow or an elephant or a duck? What is it? And that's the issue that we have to grapple with here, because it's certainly not a conventional garage with a driveway access, and that's what arises here.
One other thing, would the client be agreeable to putting in writing that there will be no bathroom or cooking facilities in this garage?
Absolutely.
Andy, can I get some, Billy, can you give us a couple of comments on this, on Main Street? Well, thank you for trying. Just so we're all on.
Good
Same page.
morning, Billy Hajak for the Village.
Thank you, Billy. So we got the building inspector's letter here from December 29th, 2025. The front door is 6 feet now, where it was supposed to go, that's the side door, where it was supposed to go to the front door, which was 7.5. I mean, can we get a car in a 7.5 foot or 6 foot door? I don't know. I'm not an expert on it, or.
I mean, the building inspector's turn-down letter states that it's not, the door that was where the driveway services, it's their opinion that it's not capable of, fitting a vehicle. I believe the door on the, I guess it would be the front of the building.
Yeah, 7.5 feet.
I think that, it was determined that that door was capable of, wide enough to fit an automobile, but that that's not where the driveway leads, and it's blocked by a statue or a fountain of some sort.
Okay. Any board members have any questions for Billy? Thank you, Billy.
Sure.
You're going to, Andy, you're going to give Tim a copy of your findings?
Yes, absolutely. I did want to, in the drawings that we submitted, there is a demonstration of the door width and some of the historical cars. Clearly you wouldn't get a Cadillac Escalade in this garage, but my client has no intention of having a Cadillac Escalade. As a matter of fact, he was a collector of vintage cars. I've seen quite a few on the property. I think he told me that during COVID, he was, he got rid of a lot of his more vintage things, but this thing certainly would fit a car. And as I said, it's the same garage width. I believe that's on the historical manager's cottage. It probably dates back 40s or 50s, thereabouts.
So I would just maybe ask if we could just clarify and confirm that the nature of the application is for a variance, correct? This was not an application for an appeal from an interpretation that was contained within the building inspector's determination.
Well, I don't believe there was a variance requested for the door width, because we believe it complies with, and it is it's accessible for motor vehicles under the village code. So a determination that would be a clarification that the board can issue.
Well, I guess a different way of asking the question is the relief that you're seeking urge the board to take an interpretation that's different from that of the building inspector?
Either a difference or a variance, either one would work at the end of the day. We believe that the two paved strips, which I was told that during construction, Tom Priato, the then village building inspector, said that was sufficient for that purposes. So there might be a difference of opinion that occurred. I wasn't personally there, but I think Mr. Deline was there. So that was done under the guise of, they were told that would suffice for their purposes. So that's kind of why one of the other factors that changed it. But in terms of automobile or motor vehicle access, we think it does comply with the village code. It's just, it's not a defined term basically, and it does in fact fit vehicles. It just doesn't fit a Cadillac Escalade or, a Toyota Sequoia or something of that matter, but that was never the intention.
Okay. We're going to leave this open. You're going to give Tim the.
Sure.
We just got this, so we'll leave it open to the next meeting to review the material you just handed in and the brief that you're giving to Tim. All right? Anybody else in the audience like to speak on this? Okay, thank you. So we'll move on to the new hearings, please. And I think we're going to do, let's do 25 Appoquog. I know Trevor's not here. If you can read the notice. Sure. Yeah, and Mr. Rose is recusing himself on this. And Jim, you're recusing yourself on this too. Yes. So sitting on this hearing will be Mr. Darko, Mr. Barris, Mr. Simons, and myself. Thank you.
This is the application of Mark LeBau and Patricia Harris, Suffolk County Tax Map Number 301-13-7-5, for an area variance from Chapter 278 zoning to legalize swimming pool equipment. A 15.4-foot variance is requested from Section 278-3A5C to legalize swimming pool equipment located 24.6 feet from the rear yard lot line where the required rear yard setback is 20 feet. The subject property is 84,725 square feet in area and is located at 25 Appoquog Road in Residence District R160. This project is classified as a Type 2 action pursuant to SECRA.
Okay, good morning. I know the applicant is not here. Is there any comments from the board on this? Okay. Anybody here to speak here? Opposing this? Okay. I don't think any of us have any issues with this application, so I make a motion. Anybody, before I close it? I make a motion to close the hearing.
Second.
All in favor?
Aye.
Aye. Thank you. Moving on to the next new hearing. Thank you, Tim.
Next will be
201.
application of 201 LPL LLC, Suffolk County Tax Map Number 301-15-4-14, for a permit and variance from Chapter 101 Coastal Erosion Hazard Areas, variances from Chapter 278 Zoning, and Chapter 124 Preservation of Dunes to install mechanical heat pumps. A coastal erosion hazard area permit and variance is required in accordance with Section 101-9 to install mechanical heat pumps and an enclosure seaward of the coastal erosion hazard area line, where the introduction of new structures seaward of the coastal erosion hazard area line is prohibited. A 17.1-foot variance is requested from Sections 124-1A1 and 2 and Section 278-3A7 to construct mechanical heat pumps in an enclosure 132.9 feet from the edge of beach grass when buildings and structures are required to meet a 150-foot setback from the southerly edge of beach grass. The subject property is 116,538 square feet in area and is located at 201 Livingston Lane in Residence District R160. The property adjoins the ocean beach and is located in FEMA flood zones VE elevation 17. This project is classified as a Type 2 action in accordance with SECRA.
Thank you, Tim. I just want to hold 1 second, Mr. Ackerman, please. Just who's sitting on this application? And I lost my piece of paper. It'll be, well, thanks, Jimmy. We will have myself, Mr. McMullen, Mr. Rose, Mr. Barris, and Mr. Simons. Okay. Good morning.
Hi, good morning. Well, it's the first of the year, and I thought I should show my face on LTV so everybody knows I'm well and
Picked a nice warm day.
healthy. My colleague, Mr. Lawrence here, he's going to give you a brief explanation of why we need to do a little bit of housekeeping on this project. Tom.
Morning, Tom.
Good morning and Happy New Year.
You have to swear.
Yeah, so I'm not the clerk, so I'm not going to issue you a formal oath, but we'd ask you to affirm that what you're about to say, it's truthful and is being given in the same way as if you were under oath.
I do so affirm.
Thank you.
My name is Tom Lawrence. I represent Bolgen and Associates, the general contractor for this project. I know it's been a long week, quite possibly the longest week of the year. You have a full agenda, and my wife advised that I speak as little as possible, just like at home. And the entire team has echoed that advice. I will follow it to the letter. This application seeks to address, as Lenny said, a bit of a housekeeping, as it were. To suffice it to say that every plan works fine on paper, but sometimes it does not translate into reality as well. So we are requesting approval of a minor change to the program. That being said, we're asking for a modification to allow the existing garage to remain in lieu of the approved wellness center, maintain the approved mechanical room, and add a mechanical courtyard on the eastern side of the garage. It's actually northeastern side of the garage, where the attached caretaker's garage, workshop, chicken coop, dog pen existed, to house 3 heat pumps in lieu of the originally proposed, or considered, I should say, geothermal system, which was found to be infeasible. The proposed mechanical courtyard, which measures 12'6" by 20 at the outermost points, will consist of 3 wood shingled walls to match the house and garage walls. Those walls will be attached at the easterly side of the garage, supported by the garage foundation on the westerly side, and pile caps on helical piles as required by code on the easterly side. The floor and walls will be elevated for both FEMA and New York State code compliance, and perhaps most importantly, airflow. And the 3 heat pumps will sit on an elevated deck constructed of open metal grating. There will be no roof. The walls will have corner braces on the interior for structural integrity, and the primary entry to the area will be via a door from the garage with a service gate on the southerly side for routine maintenance, service, and housekeeping or cleaning tasks. The 3 electric heat pumps will supply both heat and air conditioning for the residents and can do both functions simultaneously. The units are state-of-the-art, highly efficient commercial grade, and take the place of 10 to 12 or more, depending on how you zone the house, the residents. Traditional air conditioning condensers, and several traditional furnaces or boilers that most of us have at our homes. We have very thoroughly vetted this plan and know without doubt or fail that it will achieve all the project's heating and air conditioning requirements and a much higher efficiency in a dramatically reduced space. I have the full Alice's Restaurant photo array, should the board have any questions or need any clarification. Thank you.
Board members, questions?
So let's just review. Go
ahead.
Just the footprint of the structure that was approved is what, and contrast that with what is being requested now.
So I can do this without tipping over the storyboard. Here, there was a shed, and you can see in the shadow was, this was attached, and it's the caretaker's workshop and storage room with a powder room inside. And then there was an attached, semi-attached chicken coop, rabbit hutch and dog pen. So we are that's the lean-to for the caretaker storage area, and the, whatever you want to call the animal pen. So these were scheduled to be removed, and in fact have been. And what we're seeking is to attach the mechanical room in the garage is at this end of the building. And we'd like to house the 3 heat pumps in a walled enclosure, open at floor and ceiling, roof, no roof, just outside of it.
Let me repeat the question. What was approved by this ZBA, and what is the difference in terms of what is now being sought?
The footprint of the garage has not changed. We just want to attach the 12'6" by 20 closed courtyard.
So the point is you're expanding the footprint of what's being built from what to what?
From the highlighted yellow to the highlighted yellow plus the 20 by 12'6".
Okay, so
No roof on it?
Walled in.
Just walled in, just,
The floor is metal grating, so
Could you repeat why you have to do this, why you're asking for this?
explain,
Explain.
then explain why it is that that's being requested.
there were a number of issues with using a geothermal system. One, the proximity to wetlands. The building envelope is this slice through here. And we didn't want to come back to the board and ask permission to poke a slew of holes in the wetlands or the protected regulated areas. And the runs would have been long enough to diminish the efficiency of the systems. So we would have been in front of the board requesting air conditioning condensers at various points to augment the system. So,
And the programmatic change, but there's a footprint change in location, and there's a mechanical equipment, and then what's the programmatic change that warrants?
well, the garage was approved with a section of it as a mechanical space because we had to take everything out of the foundation, literally. So we found room for everything. And that also was the death knell, I think, of the geothermal system because the equipment is so large. And we didn't substantially expand the house to accommodate it and had no desire to do so. Wellness center was approved in lieu of the garage. And the programmatic shift from the client has been, no, I do need a place to both park vehicles and store them. So we now propose to leave it as partially a garage, abandon the wellness center, and install the mechanical room.
Understood.
any questions?
No, I don't have a problem with this.
I don't have a problem with it either. Ms. Fitzsimons?
Okay.
I don't have a problem with it.
Okay, a motion to close the hearing. Oh,
Thank
does anybody in the audience have here?
Linda,
Motion to close the hearing?
thanks, Tom.
All in favor? Aye. Thank you, Mr. Ackman. Thank you. Moving on to the next hearing.
Application of the Town of East Hampton, Suffolk County Tax Map Number 301-2-7-1.3.
It's not us.
Issue a special permit in accordance with Section 278-7D and variances in accordance with Chapter 278 zoning, make structural alterations to the existing building, and construct 3 pickleball courts. The variances of approximately 50 feet and 14 feet are requested from Section 278-3A3 to make structural alterations to the existing building and construct 3 pickleball courts located approximately 20 feet from Gingerbread Lane and 56 feet from Lumber Lane, where the required front yard setbacks are 70 feet. The property contains 105,096 square feet of land area and is located at 2 Gingerbread Lane in Residence District R40. The project requires approval of the Design Review Board and is classified as a Type 2 action in accordance with SECRA.
Good morning.
Yes, good morning, Board. My name is Matt Jedlicka from LK McLean Associates, a consulting engineering firm for the Town of East Hampton. So this is an existing.
1 second, he's gonna,
So 2 housekeeping things. Do we want to say who's sitting on this?
yes, myself, Mr. McMullen, Mr. Rose, Mr. Barris, and Ms. Fitzsimons.
And as you might have heard before, if you could affirm that you'll be telling the truth and providing the same testimony you would as if you were under oath.
Affirmed,
Okay, thank you.
of course. So it's the YMCA facility or the East Hampton Rec Center. And we are proposing 3 pickleball courts within the confines of the existing courtyard that's on the south side of the building. So currently there's a multi-use court in that location. The multi-use court's been striped to have 2 pickleball courts, and the town is looking to Within that courtyard, develop 3 pickleball courts. You're not looking to do anything else. It's within the confines of the existing courtyard. It's an unusual property because it's 10 acres. Both gingerbread and lumber are on the property. It's the village's property, so the village owns the property. And it goes from Race all the way to Herrick Park. And it borders the school property and then the northern parking lot of the YMCA. So even though those 2 roads are on the village property, there's still a front yard. The building department considers those still front yard setbacks. So that's why we're seeking relief, front yard setback of a building that was built in 1989 or 98.
And can you, is there lighting currently on the basketball court there, the 2 pickleball courts that have?
There's no sport lighting out there.
Okay, and is there any intentions to have any sport lighting?
No, we're not adding any sort of sports lighting or anything like that.
That's something we would look to possibly put in the determination so they can have lighting at night, or I'm just asking the question.
Condition it as.
Condition it?
Sure, if that's a representation you're making.
Would the town be willing to make that representation?
I would think so. I have to, ask the town
Just
board,
something
but
to report back.
That's great. Any questions, board members?
So, in essence, you're taking the basketball court and there's some tiered seating
there's the tiered,
taken out
right,
and expanded to 3 pickleball courts.
correct.
Are you going to keep the basketball court there
There will be,
as well?
a basketball court option. And within the hooped area, there'll be 3 striped pickleball courts. So that tiered seating is going to come out.
And as you said, there's no plan to expand outside of that footprint.
No, definitely not.
This is a question from someone who is mercifully unfamiliar with pickleball and its many dynamics, though I gather there's a noise issue that relates to pickleball in particular, and that's something that is related to code issues that we've had in private pickleball courts in the village. Is there anything, any noise issue involved here or mitigation that's warranted?
Talking about sound attenuation.
It's,
I don't see the pickleball.
I'm not asserting, again, I don't, it's a question.
So Charles Collins for the town attorney's office. Pickleball there was a moratorium previously in the village on pickleball courts that has since been lifted. Pickleball, it does make noise. There already is a current basketball court there, and I believe they play pickleball. And as of yet, and I don't know if the building department or code enforcement has heard of any complaints about noise. Directly across the street is the elementary school, so there's many young children playing and yelling, and then there's parking lots, and then there's the very busy East Hampton marketplace that's constantly packed. So I don't really foresee noise. I mean, the closest residential house that I can think of is probably Ray Hardin's house, and I don't believe he's ever said a word about it, so I could ask him, but I don't think there's any real noise implications.
I just want to make sure we put the issue on the table.
Yeah, no, understood.
For anybody else.
Thank you, Mr. Collins. Any other board members have any questions?
Yeah, it's a pretty unique and isolated spot, so I don't really think that those are concerns. They're playing pickleball there anyway. It's what's the difference if the basketball's bouncing versus pickleball? It's no difference.
Anybody in the audience have any questions or would like to speak? Okay, a motion to close the hearing.
So moved.
Second, please.
Second.
All in favor? Aye. The last new hearing of the day, myself and Mr. Rose are recusing ourselves, and Mr. McClellan will chair it. Thank you all.
Thank you.
Linda.
Tim, would you like to read the?
Sure.
posting or notice.
This is the application of Jewish Center of the Hamptons, Suffolk County Tax Map Number 301-8-7-46, pursuant to Section 278-7B1 of the zoning code, seeks to appeal a building inspector interpretation that the term residential property, as used in Section 278-3A9B, which reads, quote, driveways serving residential property, walkways over dunes, and a postman's walkway are exempt from coverage, end quote, is limited to property containing residential uses and does not apply to all properties located in a residential zoning district. Subject property is 145,643 square feet in area and is located at 44 Woods Lane in Residence District R80. The project is classified as type 2 pursuant to SECRA.
Thank you, Tim. Sitting on this application will be myself, Mr. Barris, Ms. Fitzsimons, and Mr. Darko.
Good morning.
Morning.
Like all applications, this one has a story. This story begins in September of last year when the building department issued a turn-down letter. The subject of the application for a building permit was to enclose the porch area at the Jewish Center to enlarge and make available classroom space. The Jewish Center has just come off of spending a considerable amount of energy, money, and time on building a gifted pavilion on their property, which went through extensive relief. One of the issues that was raised when that application was made was the coverage question. Since then, I've been focusing on this coverage issue, and we've done extensive amount of research. And initially, I thought, well, let's file with the DRB, let's move this thing along, let's file for the special permit. However, as a condition precedent, as you know, you can't have your special permit hearing without moving through the DRB. We filed with the DRB in October of last year. Our hearing on the DRB is now scheduled for January of this month, 21st. So in the interim, we've been spending considerable amount of time researching the question of should religious institutions in the village be subject to not only a special permit application, but the coverage issue. As you know, there are numerous institutions, religious institutions in the village who are subject potentially to this coverage issue, starting with the Methodist Church, St. Luke's Church, First Presbyterian Church, Most Holy Trinity, Church of Christ, and the Chabad of the Hamptons. So I think this is an important issue, an important question. And as all of you know who've watched my career over 60 years practicing, when I find an issue that bothers me and we need to educate on, this was one of those issues. And because of the expense, the delay, and what's been occurring here, I thought we should focus on it. And I put my partner, Linda, to the task of doing the research. And that's what we've been providing for you. So with that in mind, I'm going to ask Linda to give you a brief summary of what we've submitted to you. And hopefully you'll consider our application. Thank you.
Good morning. My name's Linda Margolin. I'm a partner with Lenny. We've submitted a lot of written materials, and I don't want to burden you with a recital of everything that's in them. Instead, I'm going to try and summarize for you what this code interpretation application is based on. There are basic principles that govern zoning enactments by a village. The power to zone comes from the state, and it comes with guardrails. I know you're aware of the one that says you can't have a zoning enactment without the power to grant the variance, but the other guardrail established by the Court of Appeals more than 50 years ago is that zoning regulations that are ambiguous must be construed in a way that favors the property owner and against the municipality. So that's the law. So the first question is whether or not residential property as used in this section is an ambiguous term. We don't think it's ambiguous, but the building inspector disagrees with our interpretation. So I think it's pretty clear that there is ambiguity. The technical term that's most often used in the code is property in a residential district. And that, in fact, is what the term that is used in the very first part of the subsection we're talking about, where it talks about coverage limits on property in a residential district. This particular section that then says that with respect to computing coverage, residential properties exempt driveways, a postman's walkway, and walkways to the dunes. So in the context of this section alone, we think it's pretty clear that residential property is a reference to the prior subsection of this paragraph. That is to say, we're telling you when you calculate coverage on property in a residential district that you don't count the coverage attributable to driveways. The code, and we've provided this analysis to you, is quite specific when it wants to talk about a residential use. It's elsewhere in section 278-3, for instance, when it talks about requiring a buffer for transitions between commercial uses that abut residential uses. So when the code wants to speak to the term residential use as opposed to a zoning district, it says so. We submitted a letter only the other day because we were finally able to pull the pertinent legislative history. There was no legislative history that explained what was being done when these first enactments took place. They took place in the wake of the 2002 Comprehensive Plan. The 2002 Comprehensive Plan suggested that the village should consider enacting laws that helped address the proliferation of structures on residential properties. And the result of that was in 2002, and then amended, I think, in 2003 and 2004, was enactments that set coverage limits for residential properties, that is residential district, and for non-residential districts. The initial setting was 20% in residential districts and 90% in commercial and other districts, later changed to 80%. But because at the same time the village enacted a very comprehensive definition of structure, it was clear that things on residential properties that would immediately make virtually every residential property in the village exceed the permitted structure were driveways. And therefore, the definition of structure had a carve-out within the definition at that time. The carve-out was for fences, for driveways, and for a single walkway called a postman's walkway that connected either a driveway or a street to a door in a dwelling. So the way that code was constructed in 2002 to 2004, driveways in residential district properties did not count towards coverage regardless of use, because the only thing that reflected use was this idea that a postman's walkway connected to a door in a dwelling. So you had to have a dwelling on the property. What happened? In 2017, the village board made significant changes to the zoning code, essentially restructuring so that restrictions that were basically embodied in the definitions section were changed, and they were put in places where one might more expect to find them. And that's what the legislative purpose says, and that's what our recent letter explains. In 2017, they said, to the extent that we already have restrictions embodied in definitions, we're moving them to the right place in the code. So what happened here was these amendments now defined a postman's walkway in the definitions, saying it had to connect either a street or a driveway to a door in a dwelling. Didn't provide a definition of driveway, but took that exemption for driveway and postman's walkway and now put it in the section that restricted coverage for residential districts and for commercial districts. So that's what happened. And at the time that the village did this, it clearly was the village board. It was clearly aware of the fact that it needed to create a definition of postman's walkway if this was the way they were going to change the code, because that assured them that the postman's walkway would be for a residential use. And they did not do that for a driveway. So we think that the history shows that it was not intended, when the change was made in 2017, to restrict non-residential use driveways in the sense that they would count towards the 20% coverage. There are other indications of intended policy in the village code, and one of them has to do with your own standards for a special permit, and the other has to do with the DRB standards for site review. Your own standards for special permit, and the Jewish Center is a special permit use, talk about the adequacy or need for bituminous surface parking. The DRB standards talk about addressing the adequacy of vehicular circulation and adequate parking. So we think that these other portions of the code show that there is a concern that driveways and parking on non-residential use properties that are in residential districts, because whether it's a special permit use or a non-conforming use, you have to go to the DRB for a site plan if it's not residential. These show that the village's policy is they want to make sure that there's enough. Not they want to restrict it, but they want to make sure that there's enough to provide adequate circulation and adequate parking. And because the 20% lot coverage is so restrictive, clearly, as has turned out here in the more recent interpretations by the village building department, virtually every property that's either non-conforming or special permit, if you count the driveway, they need a coverage variance. That was not always the case, as I will explain in a minute. We've also pointed out to you that when New York State gave the power to zone to the village, it requires something called uniformity. That's in section 7702 of New York Village Law, and that says that you have to treat all property within a zoning district the same way. And there was a recent case about 5 or 6 years ago, and we've included that also, where that specific issue was raised to the court with respect to the village law that distinguished between who could apply for a public assembly permit in residential districts and set a different standard for residential use requests and non-residential use requests. And the court struck that law down and said, you can't do that. You have to have a uniform treatment of properties in a residential district. The final thing that I will want to point out to you is that we're aware of the fact that a letter's been submitted to the board by Mr. Tarbett claiming that the interpretation made by the building inspector is one that has been in place for decades. This is simply not the case. I looked at virtually every application I could find for any kind of non-residential use in a residential district over the past, since 2002, to see how they'd been treated with respect to driveways if there was a coverage variance sought. And I can tell you that in 2004, with respect to the 1770 house, and I'm prepared to hand it up, this board granted a coverage variance, and the coverage figures were based on a survey that not only didn't include coverage that was attributable to the driveway, but the survey specifically said it didn't. It said, and I'm going to hand this up, excluding driveway and brick walks to street. So in 2004, with essentially no change in the law, driveways did not count for the 1770 house when they applied for and got a variance, a coverage variance. I believe the change occurred sometime between 2011 and 2013. That is the first time in all the applications that I've looked at that I see notations on surveys submitted to this board and to the building department that note coverage attributable to driveways for special permit uses or non-conforming uses. But the code did not change at that time. And so what I think we have here is an unfortunate instance of the building department, either on its own or by direction of someone, creating a policy that is not supported by the current version of the code. And I believe that it's this board's job to interpret this term in a way favorable to the property owner, against the village. If the village wants to do something different and feels it can justify the differing treatment of properties in the same zoning district, it can amend the code. But it's not the job of the building inspector to amend the code. Are there any questions? May I hand up the 1770s? Oops. There's enough here for everyone. And Mr.
Let's see if there's any questions.
Does any board member have any questions at this point? No? Okay. Thank you.
Thank you.
Is there anyone in the audience that would like to say something? Morning, Jonathan.
Morning, John Tarbett, represented a few neighbors who are concerned about the appeal of the building inspector. The first thing I would say, I did say decades, and that may not be accurate. I do know that the one I handled was landscape details, which was a pre-existing non-conforming restaurant and became an office. And in that case, which I think is about 10 years ago, though, please don't hold me to the exact date because I didn't look at it before the meeting. But in that case, we did need a coverage variance, and driveways were counted. We actually asked for a variance for that issue. So that's the one pre-existing commercial property in a residential zone that I can think of. As far as...
Sorry, do you have the address for that?
I'll add it after the hearing. That's another thing I was going to ask, if possible, the record could be held open. We had the holiday breaks. I just got back on Monday. I got retained this week, and I think it's a pretty important question that hopefully we'll have time to at least spend the next 30 days looking into. What I presented to the board by letter this morning was a very quick review. But I will hopefully, if the record is held open, give you that address. So essentially, to simplify matters, the code has a section that says that on residentially zoned areas, you can get 20% coverage. In commercially zoned areas, you can do 60% coverage. And then it says residential properties, you don't count driveways. One thing that wasn't discussed by the applicant's presentation is that on a residential property, a driveway is what you think it is. It's a driveway with a couple parking spots. On a commercial property, a driveway could be a lot of parking. So this is a significant issue. You think about the old car dealership on Panago that's now Hildreth, I think it's Hildreth's. You think about all the parking there. Well, driveway would include all that parking. So if on a commercial, if in a pre-existing non-conforming commercial building, a residential zone was allowed to exclude driveways, what you're actually saying is all the pavement, which is parking, and that could be a significant amount of parking. The other issue is that we don't think it's ambiguous, right? Just because you disagree with the building inspector does not make something ambiguous. The code says on residential properties, you don't count driveways. In order to follow the applicant's argument, you have to accept that residential properties is ambiguous and somehow could also mean commercial properties, which to me doesn't seem ambiguous. But the other thing they didn't discuss, well, two things. One is that there's a separate section of the code, which is the definition of coverage. So I would ask the board to take the time to read the definition of coverage in the code. It also deals with this issue. And also, what you need to understand is that if you were going to take, so the code says residential zone, commercial zone, and then it says, hey, for residential driveways, you don't count coverage. If you were to adapt the applicant's argument, then residential properties and commercial zones would not be allowed to exclude coverage, which That would be a giant jump. So here we have a section of the code that says, hey, on residential properties, you don't need to exempt coverage. You do exempt coverage, but under the applicant's argument, then if a residential property was in a commercial zone, you would have to include coverage, which seems counterintuitive.
Would that work in the reverse thing as well, if there's a commercial piece of property in a residential zone?
Yeah, that's what they're trying to.
A residential piece of property in a commercial zone, how will that affect?
Right, so if you adopt the applicant's argument, which is that residential property really means residential zone, then that's exactly what it would do. It would allow commercial properties in residential zones to not count parking and driveways. But it would counterintuitively, a house in a commercial zone would have to count their driveway, which doesn't seem to make sense. The rest of my argument was submitted in writing. It's a complicated argument. Even for someone who does zoning all the time, you have to sit and read the code, read the arguments. They've submitted their argument. I've submitted my argument in writing. Hopefully, it can be left open just for 30 days, just so that the board can review both arguments. And again, it's not an easy. When you talk about code interpretations, it's complicated. The only other thing I wanted to point out was. This is one of those rare cases, unlike a variance for an area variance. The building inspector is the person charged with interpreting the code, and this is one of those rare chances where the board actually gets to stand in the shoes of the building inspector. So if you were to overturn the building inspector, you would essentially be acting as a building inspector by determining what the code says. You can probably get a feeling for how tough his job is, because all these building inspectors have to do this on a daily basis. But in this case, the building inspector has already determined what he thinks, based on his years of experience, the code says.
Thank you.
Thank you.
Linda, would you like to?
Thank you. If you look at the code is not ambiguous about what coverage is in any district that is not residential. It used to be 90%, then 80%, it's currently 60%. That is, an order, that is 3 times as much coverage as is permitted in any residential district. And I would be surprised if there were a residential property in a non-residential district that had a problem with coverage, but if it did, they'd come to this board, and this board would presumably give them a variance. There's no ambiguity with respect to that provision, that portion of the code. It's quite clear. The question is, this subsection B, what was it intended to do? Was it intended to set a separate standard only for residential use properties in residential districts? Or was it intended to modify the paragraph that came immediately before it, using a shorthand term, residential property, to refer to the term that it was in the immediate preceding paragraph that says property in residential districts? So, as far as this being the board, this board is not taking over the job of the building inspector. This is one of the functions of a zoning board that I understand comes before you rarely, code interpretation. But it falls within your jurisdiction, and we look forward to your interpretation. We have no objection to the 30-day adjournment.
No, just let me say something. If there's a concern here that there isn't going to be adequate review, obviously there's going to be. It's a special permit, so got to come before the ZBA. There's DRB, got to come before the DRB. We're burdening you to make this interpretation, to send a message to the village board that they need to clarify the statute and make it clear. The building department is issuing a determination based on policy. The leading case, when I first came to town, it's called the Ashman case, dealt with policy. The town interpreted outside the statutory provisions that were in place that the dune area in the town was included in calculation of the eligibility for building permits. There was a policy. We went up to the appellate division and we had that reversed. You can't urge policy. You have to have clear statutory provisions. And that's what we think needs to be done here. And I'm sure council would agree with that. We shouldn't have to be coming to you for everyone. When you look at the burden, every one of these applications in the village where you have non-residential uses in commercial zones have required a coverage variance. It's unnecessary. Let the village decide what it's to be, and you can send that message very, very clearly. Thank you.
Thank you.
Motion to leave the hearing open.
Okay. Does anybody else in the audience have anything to add? I have a motion to keep the.
If I may just, if you're possibly coming back, a question for Linda that, might be helpful. You had talked about, statutory construction and principles of it.
Sorry, Mr. Hill, I can't hear you.
So you had mentioned, that there are principles of statutory construction and that ambiguities are to be resolved against the village and in favor of the owner. You're indicating, if your argument, as I understand it, in part, is that subsection B, the reference to residential property there, is a shorthand, I think you said, for the description in A, which does explicitly refer to land in a residence district. Is there also a canon of statutory construction that says where there's a difference between the terms in the code, that difference has to be given meaning?
Well, I'm glad you asked, because the question is, in order to see what's meant by the term residential property and see whether it means residential use or is just a shorthand term, we examined the entire code to see how much the term residential property was used and how it was used and how the code used the term residential use. And I don't want to burden you with all that detail. It's in our written submissions, but it's pretty clear to us, and we think it should be clear to you, that the code uses the term residential use when it wants to talk about a use, and that the term residential property is a shorthand term, an unfortunate shorthand term, I would say, because it's not clear and it's not defined, to refer to property in a residential district. So it is, when you see, under a principle of statutory construction, when you see that the people who enacted this code knew how to use the term residential use when they intended to refer to a use as opposed to a zoning district, then I think you look at the term residential property, in quotes, that doesn't use the term use, and what you determine is that if the village board knew enough to use the term residential use when it was referring to use, the absence of the term use means you should not read the section that way. It is the Latin thing that I can never remember, inclusio, exclusio, whatever it is.
I'm not taking it.
That's what we think one of the traditional maxims of statutory interpretation would tell us. But I think the overarching important principle here is that if it is ambiguous, the Court of Appeals has said quite clearly how it has to be read. It can't be read in a way that imposes a greater restriction on the property owner. It must be read in a way that imposes a lesser restriction.
So you understand, Tim, that we're making a record, and we can apply, notwithstanding the determination of this board, for a variance and move this project along. But I think this is an important question. It's either going to be decided in an Article 78, or it's going to be decided by a change in the law clarifying whether a non-residential use in a residential zone should be treated differently. Right now, our statutory scheme doesn't provide for that with clarity. And I think I just mentioned non-religious institutions that could potentially have the burden of another application. Look in the case of the Jewish Center, DRB, special permit, variance on coverage, and DRB. I mean, it's an incredible exercise of time and money, notwithstanding that I'm working pro bono for this. It's still a burden that I think is unnecessary. But I appreciate your comments. I appreciate you and your partner's participation in this discussion. I think it's an important discussion we should have. Thank you, Tim.
One more question, Mr. Ackerman. You mentioned the religious institutions a few times, but just to clarify, this interpretation affects more than just the religious institutions, right? It's any commercial use in the residential.
Any non-conforming use. And potentially, as we pointed out in our papers, any non-residential use. So what happens if you have a residential use on a property and you also have a home office, or you also have a greenhouse? There are non-residential uses that are permitted in the residential district. There are special permit uses, and there are non-conforming uses.
Well, Moran Museum, Guild Hall, LVIS, they're all part of that scheme. It's not just restaurants. It's just not Baker House or 1770 House. Yes, a lot of people are caught up, a lot of institutions, businesses, whatever, are caught up in this, but also a lot of not-for-profits in addition. I'm raising it on the question of the Jewish Center.
I mean, this is basically a function of history, because once upon a time, everything important in the village was all in the same place. Much of that is now zoned residential, but it wasn't originally constructed as residential.
They got to go to lunch.
Okay,
So do we.
I'm sorry.
Thank you very much. Thank you.
Thank you very much. I would ask for a motion to keep the hearing open.
Second.
Second.
Second, all in favor?
Aye.
Thank you. Motion to close. Andy Barris, close the hearing. Meeting. Second. Yes. Second, all in favor?
Aye.
Thank you. Thank you, everybody.
Thank you, and you are